When your medical malpractice case comes on for a pretrial conference, what does that actually mean? And more importantly, what does it mean when the defense says they need more time? You want to know the answer? Come join me for a walk as I head to the train this morning as I share with you the answers to those questions. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. Okay, when you bring a medical malpractice case in the state of New York, after you have finished discovery, after there are no more depositions, no more documents have to be exchanged, you have to notify the court that your case is technically ready for trial, which means that you will put the case on the trial calendar. And depending upon which county you are in, it's then going to sit there for many, many months. It could be 6 months, it could be 12 months, it could even be more. So now, when your case gets called for a pretrial conference, the attorneys have to go into court and now conference the case with the judge. The judge will want to know a number of things. What's this case about? The judge will want to know what is the settlement position of each party. They will want to know whether this case can be settled. Is it possible? Have you had settlement discussions already? What are the issues here? How much time will you need to actually try this case? Now, when the judge asks the defense what their position is, there may be an instance where one or more of the defense attorneys turns around and says, Judge, we have not had an opportunity to conference this case with our principals, with the insurance carrier. Can we have additional time to do so? If this is the first time that this case is on for a pretrial conference before this judge, there is a good chance that the judge is going to give the defense attorney an opportunity to go ahead and conference this case. Why? Because there is a potential for settlement, or at least there's a potential to begin settlement discussions. And now, if the defense needs some additional time in order to get authority to start negotiating, it may be well worth it in everyone's interest to get that additional time. So that's what it means when the defense says, hey, judge, can we get some additional time? We need to conference the case. So once the judge has an understanding of what everyone's settlement position is, now the judge can turn around and say, okay, I'm giving you 2 months, come back and let me know what the carrier has to say. At that point, we now come back, this is now the second pretrial conference. If the defense comes back and says, Judge, I'm sorry, this is a no-pay case, we have no interest in trying to negotiate or settle this case, now the judge knows exactly where this case is going. It's going to trial. And the only question is, okay, when is everybody available for trial? When is the court available? When are the attorneys available? When are the experts available? At that point, the judge will likely set a trial date down. However, what happens, though, if the defense now comes back, this is the second pretrial conference, if the defense attorney comes back to the judge and says, Judge, listen, we conferenced the case, we need some additional time because we have to do X, Y, and Z. Maybe we have to sit down with our doctor to now convince him that he should begin negotiating. Maybe we need to conference this case again because not all of our principals were available. Whatever the reason or the excuse is, now, again, if they are willing to try and negotiate or to settle this case, the judge has a better understanding as to what their settlement position is and whether it's worthwhile to bring them back again for another pretrial conference. At some point, the judge is either going to get fed up with their excuses or the judge is going to say, enough. We're done. There's no further discussion. I'm setting this matter down for trial. If you're not settling it before then, fine. We are going to trial on this particular date. So why do I share this quick information with you? I share it with you just to open your eyes because, in fact, I just came back from court having a pretrial conference where the defense said exactly that. Judge, we haven't had an opportunity to conference this case with our principals. Can we get some time? And the judge recognized this was the first time on, and now there's the possibility that we might be able to enter into settlement discussions. So the judge went ahead and gave the defense some time to go ahead and conference the case with their principals, and hopefully when we return back to court shortly, now the defense will have a definitive answer as to what their position is. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.